Thank you. It's a great treat to be back here. As some of you know, I taught here for more than a decade, and I miss this place in 1,000 different ways, and it's just been a real thrill to return. Thank you for having me. I showed my wife the program before coming down here, and she just started laughing when she saw that I was supposed to be on the eclectic panel. I love her dearly. She says she loves me dearly, but the last thing in the world, the last word in the world that she would use to describe me is eclectic. I mean, her greatest grievance is that she happened to marry a guy who's so much of a hedgehog, so much of a one-track mind kind of guy. So I'm relishing this role as being a part of the eclectic crowd. My particular interest is the history of ideas relating to free speech, and I thought it might be useful to put this morning's debate into a somewhat broader historical perspective. So let me try to do that. I think that it's true from my study of the classics, so to speak. I teach a course that's built around what I take to be the 7 leading arguments in the Anglo-American tradition about the freedom of speech by John Milton, James Madison, John Stuart Mill, Learned Hand, Oliver Wendell Holmes, Louis Brandeis, and Alexander Michaeljohn. Until 1925, all of the important general arguments about the value of free speech, in my interpretation, took the form of arguments about the good collective consequences that would follow on balance from a robust free speech principle. John Milton presented his argument in terms of the collective good of salvation. James Madison, the collective good of political stability. John Stuart Mill, the collective good of progress. Oliver Wendell Holmes, the collective good of adaptation to changing conditions. Darwinist that he was. Somewhere in the middle of the 20th century, a certain despair, perhaps, or becoming modesty set in which people who were making arguments about the importance of free speech came to feel uneasy about blithe global claims about collective consequences, that the claim that a certain free speech principle on balance will have good collective consequences seemed to be something that cried out for empirical demonstration and was embarrassed by ready-to-hand counter examples and so forth. And so there began a kind of search for ways to justify free speech that didn't depend on these ambitious claims about collective consequences. And I think the first example of that was the effort made by some progressives around the time of World War I to justify free speech as something that is entailed in the earlier commitment to democracy. It's not an individual right against the majority, it is a majoritarian procedure. It's a way in which we discover what the true majority is or what the emerging majority might be. But then what happened is that when you get to the first level of detail, it turns out that while it may be uncontroversial to say that we have set up a system of government that commits us to democracy, of course even there, the text of the Constitution doesn't use that word, it uses the word Republican form of government, and at the time of the framing, the debates were in terms of how to save our republic and what does Republican government entail. But in any event, once you get beyond that first level, then you see all sorts of new controversy enters the picture, where Learned Hand thinks that the reason to have a robust free speech principle is because consent of the governed is the foundational principle, but he takes from that a belief that explicitly advocating violation of law is not within the ambit of protection because there is a rule of law commitment that's also entailed by the commitment to majority rule. Brandeis makes an argument that builds from the starting point of a commitment to democracy, but his argument takes the form of a character ideal. We need certain kinds of citizens in order to make democracy flourish. Alexander Michaeljohn built an argument from this starting point of the commitment to democracy, but his emphasis was on the empowerment of listeners planning for the common good. He used a famous example of the town meeting, but it was a listener-oriented theory of democracy that was very demanding in terms of what the motivations of the voters, the listener voters, needed to be. One of Calvin's proteges was my free speech teacher, Harry Calvin Jr., who interpreted the New York Times case, and I think probably altered the way that case was understood, by emphasizing the court's dictum that speech on public issues must be uninhibited, robust, and wide open. And that evolved into a view that what democracy really entails is this kind of gloves off, no holds barred, everything goes, more is always better energy. Which is rather different than the very structured conception of democracy that I think Michaeljohn had, and I'd say Brandeis as well. So it turns out that starting from the shared commitment to democracy can take you in lots of different directions and doesn't help you very much at all in addressing these boundary questions or scope questions that Robert and James have put at the center of their analysis. And so I think in a way, the democracy turn didn't turn out to do the work that many people hoped it would do. And again, it was out of a kind of despair about making judgments or finding consensus about what commitments really entail or what collective consequences really would follow. And so what happened, I think, is in I'd say the last 20, 30 years, after I even started teaching the subject, what I call a turn toward more individual-centered theories of free speech. That if we can't really agree on what the predicted collective consequences will be, and if we can't really agree on exactly what is entailed by the commitment to democracy, maybe there are other kinds of arguments that will establish a strong free speech principle, and the starting point would be notions of autonomy. Now, you've heard three very different, very carefully worked out, I think very sophisticated conceptions of autonomy. I can add two more that I think should be part of the conversation. One is developed by my colleague at Columbia, Professor Joseph Raz, who argues that ultimately a very good argument for free speech is the way in which it serves the objective of the value of individual autonomy. But individual autonomy is something that cannot be achieved in splendid isolation. It depends very much on access to the collective resource of a public sphere. And part of what that public sphere offers is not, in Raz's view, is not just a fund of ideas or opinions that you could selectively draw upon. It also offers a culture, a process of public validation, and that what it means to be autonomous is to have a rich menu of socially validated choices available to you in order to determine and develop your own individuality. That's a different kind of autonomy theory that I think belongs in the conversation. I would say the autonomy theory that probably comes closest to widespread acceptance in the case law is an autonomy theory that's listener-oriented, and it essentially does take more the form of more is always better. That listeners need the fullest fund of available knowledge and opinion, and any effort to kind of structure what that public fund looks like or to collectively determine what the listener's experience might be is problematic. It's something of an anti-paternalism commitment that trust listeners, give them everything, don't worry about the distribution of these resources, and that's what autonomy really means, is exceptional trust in individual listeners. But these are all efforts to think in individual-centered terms rather than in collective good terms. And now, I think in some ways that even that kind of charting of the landscape is incomplete, in that there are additional collective good arguments for free speech that I think have not been in the conversation and are not part of the standard litany that Robert and James began their whole analysis with, democracy and autonomy and whatever you think the marketplace of ideas or truth-seeking entails. I think there's been an aversion to many of these claims about collective consequences because they seem too ambitious, too perfectionist. Truth-seeking almost seems arrogant. And what is truth after all, and why should we believe that a robust free speech principle leads to truth? But there are more modest arguments grounded in claims about collective consequences that I think are more empirically plausible and less ambitious that also should be part of the conversation, I think. One is, and I think this was actually Madison's approach, that what you need a robust free speech principle for more than anything else is as part of a system of checks and balances in order to not perfect democracy in the sense of being as purely representative as possible or in the sense of allowing people to realize themselves as citizens in some ambitious way, but simply to check the worst kinds of abuses, to minimize the likelihood of enormities. That may be a good reason to commit to democracy. There's a debate in international relations that democracies don't make war as readily as other forms of government. So that's a different claim about collective consequences. A regime of free speech allows a more robust checking process that reduces the worst case scenarios. That's the real priority. Another is to read Holmes differently than most people do, and that Robert, for example, does. And that is, when he talks about the marketplace of ideas, you could read it to mean trust listeners, more is always better. You could read it to mean rigorous truth-seeking process. In the end, will wind up coming closer to some objective truth by virtue of all the opportunities for participation and decentralization of authority and so forth. But you could also read the marketplace metaphor to be saying something important about embracing the reality of a dynamic society. The world is constantly changing in front of our very eyes, and the only way we can cope effectively with that is to have a sufficient flexibility both in our institutions and in our character, so as to be able to adapt to these changes. And I think that's less ambitious than grounding your argument in terms of the collective consequence of truth, but it's extremely important to human well-being to have this capacity for adaptation. So the bottom line here is that what Robert and James are doing is part of a much larger picture. I think where they fit on the map is that they are trying to offer an individual-centered version of the democracy theory. That is, the kind of controversy that I suggested follows the different approaches of Hand and Michael, John, and Brandeis and Calvin. They avoid that, they believe, by reading the commitment to democracy to say something about treating the individual citizen as having a kind of political autonomy, a claim by virtue of the commitment to popular sovereignty, which is not very controversial. We have made a commitment to popular sovereignty, to be able, a claim to be heard and to hear one's voice reflected in the larger public discourse. And so I think that's where it's a very imaginative and I think a very intriguing move. I have many misgivings about it. I've written in the exchange that our group has been doing online. Some of my specific misgivings, in the interest of time, will just hold them for a later occasion. But I think that that's part of what's going on. Let me just add two other closing observations in the spirit of just trying to map the debate. One is that why do we need a robust principle of free speech? Why are we working so hard to justify an extraordinary level of protection for free speech compared to lots of other valued rights? I think a lot of it really is grounded not only in believing free speech is particularly valuable, but also that it's particularly vulnerable. That there are reasons for institutional distrust in the realm of regulating speech that might be more powerful than the reasons for institutional distrust in other realms. Why can't we just make that the argument for free speech? Now, there have been challenges. Is speech more vulnerable than other kinds of claims and rights and so forth? But I think part of our motivation is to really find a strong free speech principle is because we need it in order to erect barriers against predictable abuses of regulatory power that we don't think are quite as predictable in other realms. Finally, and this is prompted by Judge Kaczynski's remarks, we feel partly it's such an interesting time to be worrying about free speech theory. The flow of cases from the Supreme Court in the last couple of years is spectacular if you really are interested in free speech theory. Cases that really push you to the deepest theoretical questions in a hurry. But it's also the sense that our world is changing so fast, not least in terms of our patterns of communication and the changes in the authority that tends to mediate experiences of communication. Maybe a lot of our old commitments have to be rethought. Why wouldn't they have to be rethought if we're communicating in a different way? And if power relations in the realm of communication have been altered in a very dramatic way, of course we need to rethink. But there's one cautionary note that I would introduce by virtue of my particular historical emphasis, which is every time, in every era, going back to John Milton, when there was a desire to regulate speech in a systematic way that we look back on in retrospect as unfounded and dangerous, a key argument was never before has the world looked like this. In Milton's day, never before had public opinion mattered so much in constituting political communities. Never before had there been the mass medium of pamphlets, written in English of all things, available to unlearned people. And it was a deep threat to political instability. The World War I dispute, never before had we attempted to fight a war that required the mobilization of the civilian population in war production. Never before had we had such a demographically diverse community. Many people coming from cultures in which democracy was not part of their cultural inheritance. It's a whole different world demographically. We have to rethink these, optimistic principles of liberalism. The McCarthy era, the atomic age. Never before had we had the power to blow up the planet. Never before had we faced an adversary systematically attempting to destroy us with vast resources. So when we think that in the age of the internet, never before have we faced these kinds of challenges, it is true, but it's very easy to overreact to that as well.
Thank you. Our next speaker is Fred Schauer, but before I turn the podium over to him, which I do with great enthusiasm, I should have mentioned, both to our presenters and to the audience, that the ideal length of each discussion here is 15 minutes. The permissible length is somewhat longer, I fear, simply because what you're saying is always so interesting that it's almost impossible for me as a moderator to bring myself to even pass you this little thing that says you're running out of time. So I'm hoping that you will monitor yourselves and that you will forgive me if it turns out that that's just too hard to do. So with that, Fred, I know what we can expect from you, which is something wonderful.
Which is to stick to his assigned time. As a former appellate litigator, I know that when the red light goes on, you stop. period. It's not entirely clear, as Lillian mentioned, what the designation of this panel as eclectic means. Is it the idea that each of us are individually eclectic, or are we eclectic in the aggregate? That is, are we four people with one-track minds, but we're on four different tracks? Or to put it somewhat differently, can you make a fox out of four hedgehogs? So with that said, as with a few of the speakers this morning, I want to talk about methodology and to make 3 and 4, if I have time, methodological observations. So first, although we are talking about competing unitary theories of the First Amendment, is it about participatory democracy, or is it about autonomy, or is it about something else? There's no reason to think that the First Amendment does only one thing, or serves only one purpose, or is explained by only one theory. So I don't mean here to make an argument similar to one that Steve Shiffrin has made at times about the necessarily more particularistic or more fine-grained or more contextual nature of First Amendment doctrine and theory. Rather, I want to suggest instead that just as torts might serve goals of both deterrence and compensation, criminal punishment might be in part about deterrence, part about rehabilitation, part about retribution, and so on. The First Amendment might be in part about protecting art and music, in part about increasing knowledge by allowing challenges to the conventional wisdom, in part about ensuring various different democratic goals understood in different ways, and that each of these parts might have its own doctrines, its own history, and its own theory. Just because it is only one phrase, freedom of speech, and only one amendment, the First Amendment, it does not follow that we are dealing with only one legal category or only one constitutional category. Indeed, once we recognize that the First Amendment, as we now understand it, is at least in part a product of a number of diverse historical circumstances, whether it be the protests around the period of the American Revolution, or a reaction against the Comstock Law in the late 1800s and subsequent censorship of art and literature, or a reaction against the Red Scare of 1919, or McCarthyism of the late 40s and early 50s, or a adaptation to the civil rights demonstrations of the early to mid-1960s, or the anti-Vietnam War demonstrations of the mid to late 60s, and so on. There are a number of different histories, there are a number of different problems, and therefore it should not be surprising, or at least we should keep on the table, the possibility that there are a number of different First Amendments, and that thinking that just because we are dealing with one phrase and one amendment, we have to deal with one doctrine, one set of doctrines, and therefore one theory. So I want to be agnostic about whether it's one or more than one, but we shouldn't assume at the outset that it has to be only one. Okay, second, and overlapping with some of Shauna Shiffrin's methodological observations this morning, we need to recognize, as I think Robert did partly in his response this morning, the normative side of interpreting a tradition. And I think I want to talk a little bit more about the normative dimensions of what it is to say that we are interpreting a tradition. A little bit of this normativity is captured in the distinction, as used somewhat more precisely, between explanation and explication. and that somewhat more technically, when we say we are explicating something, we recognize that we are going beyond description, we are going beyond explanation, and adding something rather than just explaining and describing. So in particular, when we talk about explicating or explaining or interpreting or drawing something out of our First Amendment tradition or our First Amendment doctrine or something of that sort, there are two problems that we ought to be aware of, two problems that make the normative dimension of that particularly obvious or particularly problematic. One of them tends to go by the label in the philosophy of science of theory-laden observation. Out there in the legal literature, I don't know whether it was first said by a judge or first said by a commentator, but in the context of using history or using original intent to illuminate law, it was observed that doing this is often like looking out over a crowd and picking out your friends. The basic idea is when we look at a large, complex, multifarious tradition over a very long period of time, are we interpreting the entire tradition, or are we picking out the things that are congenial and conveniently ignoring the things that are not so congenial, in which case our first-order normative theory is what's really doing the work. Or as another judge once put it, are we using the various different items from the tradition in the same way that a drunk uses a lamppost, more for support than for illumination? Let me give two examples of this problem. The problem of looking out over a tradition, imposing a theory on it, and saying instead that the theory or the account or the explanation comes out of the theory. First example. Since the mid-1970s, more or less, going back to Virginia Pharmacy, going back to First National Bank of Boston versus Blasi, there has been in the United States some considerable protection of speech that is offered by profit-making corporations for profit-making purposes. If we recognize that this tradition goes back to the mid-1970s, then depending on whether we think that the modern First Amendment tradition starts in 1919, as many do, or instead if we think that the modern First Amendment tradition starts in 1964 with New York Times versus Sullivan, as some people do, we are still talking about somewhere between 40% and 75% of that tradition in terms of a timeline has been dominated or at least substantially occupied by corporate speech. It may be a bad idea to have decided Virginia Pharmacy the way it was decided, as I in fact believe. It may be a bad idea to have decided Citizens United the way it was decided. But to suggest that speech by corporations is an outlier to the modern First Amendment tradition may be extracting more out of the tradition or imposing more on the tradition than one can get out of it. Or similarly, since the beginning of the First Amendment until today, it has been constitutionally permissible for the government to restrict the sale and distribution of legally obscene materials. Many people disagree with that. Is that part of the tradition, or is it too an outlier? At some point, once we recognize that there are a large number of different outliers, it may be that the theory is doing the work and that we're not really explaining as much as we are using a theory not derived from the existing tradition to decide what parts of the tradition we like and what parts we don't. But third, I think the problem with defining free speech theory as explicating a tradition is that makes the task a very conservative one in the non-political sense of that term. It is not just that relying too much on the tradition is selective, but it is also that relying too much on the tradition crystallizes the tradition, to use a word I don't use very much, reifies the tradition. It makes the tradition perhaps more important than it ought to be as a strictly theoretical matter. So it takes off the table a number of questions that might be of great theoretical interest. For example, if we didn't have the First Amendment, would we want it? Now, we might think that's a silly question in the United States, but it may not be such a silly question in Somalia, Afghanistan, Mongolia, or New Zealand. I add New Zealand because it's an important question not only in terms of countries that are just beginning to create any semblance of a government, but also an important question in the context of countries that do not have a tradition of a strong written constitution and judicial review. And although the New Zealanders would say free speech is really nice, they would think of it as merely one value among large numbers of others in a quite complex common law tradition. So the question of, if we didn't have the First Amendment, would we want it? If we didn't have a separate and strong protection of strong constitutional protection of freedom of speech, would it be a good idea to create it, is not a question that is without practical as well as theoretical interest. Indeed, the question becomes even more important once we look around the rest of the world. Late this morning, it was mentioned that to ask an abstract theoretical question like this without reference to our tradition is sort of like imagining that we have come from Mars. I think that's an unfortunate, perhaps, way of putting it. Once we recognize that the United States, among the community of open liberal democracies in the world, is to a considerable extent a speech protective outlier. We are more protective than any other open democracy on the question of libel, more protective than any other open democracy on the question of hate speech, more protective than any other open democracy on the question of publication of speech that was illegally obtained, and we can add some number of others to this. So if we want to ask the question, how much should the United States look to the rest of the world? How much should it be open to the rest of the world? Or how much should the rest of the world look to the United States? Both plausible and contemporary, and questions of contemporary importance. The somewhat more foundational, fundamental, skeptical question becomes important. Indeed, asking the question about free speech in a very skeptical way has a quite distinguished lineage from a number of quite diverse political perspectives. Catherine MacKinnon, the feminist, Larry Alexander, the libertarian, and Ronald Coase, the economist, all have asked foundational, fundamental questions about is free speech any different, is speech any different from anything else, and is there any reason to protect it specially? MacKinnon says action speaks and speech acts, and in somewhat less fluid ways, Alexander and Coase and some number of others have said the same thing. So there may be good theoretical and practical reasons to say, let us not engage in an inquiry, or at least recognize the pitfalls of an inquiry. There's nothing wrong with historical inquiry, nothing wrong with trying to interpret a tradition. But let us at least recognize the pitfalls of what the pitfalls in terms of what we might be avoiding, what we might be putting off the table by engaging in the inquiry that way. Finally, we've heard some today about music, about diaries, and things of this variety. It may be useful to recognize that most of constitutional law think about the Third Amendment, and most of law in general is a reaction to actually perceived threats. My favorite example, some of you have heard this on far too many occasions, are the signs on the Massachusetts Turnpike that warn drivers on this limited access, high-speed highway not to back up if they have missed their assigned exit. You don't see these signs anywhere else. It tells you something about Massachusetts drivers, that Massachusetts would think it important to warn against behavior that people in the other 49 states would think of as totally unthinkable. So too here. The question of diaries, the question of music and the like may be important, but it may be a pitfall to developing a First Amendment theory if we are worrying too much about non-actual threats rather than developing a theory about what are the problems likely to be encountered and what theory, what understanding, what account of the First Amendment will best enable a society to deal with that. And with that, my time has expired and I will stop.
Excellent. In every possible way. Professor Shiffrin, can you do as well?
Very doubtful.
Oh, but you're sitting next to me.
It will be easier.
That's right.
32 years ago, I wrote an article defending an eclectic theory of freedom of speech and kept doing it until I got bored with it and then turned around and contradicted myself. Here's what I meant by an eclectic theory of freedom of speech. Too many values interact in too many complicated ways to be able to expect that out of that social reality you could have a triumphant value emerge, or even a small set of values lexically ordered, which would either describe First Amendment theory or would give you a good normative pathway into First Amendment theory. Free speech includes many values, including liberty, self-realization, freedom, and autonomy, but also truth, justice, or the combating of injustice, adaptation to future change, democracy, equality, association, freedom of thought, and even order. At the same time, the exercise of freedom of speech can interfere with many values, such as order, reputation, privacy, decency, and intellectual property, among others. In dealing with these conflicts, the court has balanced the relevant values at stake, sometimes creating rules, sometimes creating standards. I have always thought that's what they should do, that they should balance. I haven't quite argued for contextualization. What I have argued is that there should be general balancing in which the court should determine whether to have a rule or whether to have a standard in which there would be contextualization. And I think it's important to notice that if I'm right, that there is no theory, by theory here I mean a single value or small set of values that has lexically ordered, that has determined court decisions, that it is not necessary for clarity to have such a theory, so long as you end up producing rules across a broad range of areas, you have clarity, even without a theory in the sense that has been mentioned here. I don't believe a theory has dominated the court. I think Isaiah Berlin, with his emphasis upon value pluralism and tragic choices, has offered a better description of First Amendment doctrine than Habermas, Jim, Robert, and even Ed Baker. It would be surprising if politicians wearing black robes making compromises had a theory or produced a theory. It would be even more surprising if a court led by Chief Justice Rehnquist and more recently Chief Justice Roberts produced a theory that would satisfy Robert Post or Jim Weinstein. I can't imagine Robert Post saying that the equal protection doctrine of the Supreme Court was, what we should, is attractive in the slightest way. I want to talk for a minute about the political participation democracy theory offered by Jim and Robert. I agree that political participation is a very important part of democratic theory and is incredibly important in terms of legitimacy. It is a necessary but not sufficient condition. I agree that a vital public sphere, a public sphere that includes, let's call it a democratic culture, as John Dewey would, a culture that includes much more than politics, stuff that may never be political, is a vital part of a democratic country. I do not agree that it is at all helpful to maintain that Americans engage in self-government or that they are the authors of their own laws. That is a fantastic metaphor. The idea that I, with hundreds of millions of people, am the author of the laws strikes me as dramatically counterintuitive and, I think, a bad idea. And here's why I think it's a bad idea. I think that if you're going to pick a center of the First Amendment, that center of the First Amendment should not be a particular value, but a particular practice. And that value is dissent, challenging existing customs, habits, traditions, institutions, and authorities. And I think it is particularly important because although it's important to try to legitimize a government, I don't believe you can ever have in a large-scale society a legitimate government. And the reason I don't think so is that all large-scale societies will be riddled with unjust hierarchies, both at the governmental level and in schools, hospitals, prisons, and institutions of a private and public character. The problem with seeing ourselves as authors of laws, I think, encourages a quiescent citizenry. I would rather encourage a public who doesn't see the laws as something that they have authored, but rather something that has emerged as a result of a process, and that it's up to them to challenge those laws when they think those laws are wrong. I would want to encourage them to challenge existing customs, habits, traditions, institutions, authorities, and laws. The next point I want to make is we do not live in a land of political participation. I don't think this is a criticism of Post and Weinstein, except that it shows that we are making compromises with respect to political participation, not only within judicial doctrine, but within the entire structure of the country. I'll mention four things. The first is the winner-take-all system surely discourages political participation. It encourages a two-party system. It encourages that you get a whole lot of ads in one state rather than another state, and so forth. Secondly, gerrymandering. Gerrymandering takes away competitive seats. It's designed to take away competitive seats. It discourages participation. There is no question about it. Third, the United States Senate. The United States Senate can hardly be described as something that provides us with a land of equal political participation. And it has a political impact in which conservatives have much more power because they happen to be concentrated in a lot of small states. And then finally, I will mention corporate money. And that hardly speaks to a land of equal political participation. When you're allowed to pour in more money than others, that it doesn't look as if you are valuing political participation. That's why Jim says he doesn't like United Citizens. That's why Robert, well, I don't want to put words in your mouth, but both of you said you're not in favor of Citizens United. Finally, how am I doing?
You're doing great. Just keep up.
How much time?
Actually, you've got about 5 minutes.
Good. I want to talk a little bit about the lack of fit of this theory. Political speech in public discourse is obviously limited in a wide variety of circumstances. Brandenburg versus Ohio limits political speech. New York Times versus Sullivan. Harper and Row with respect to an article in Nation that was political because of intellectual property. The public forum cases, a long line of cases in which dissenters involved in political speech are trying to get access to public property, and the court says, we're not going to look at whether this is incompatible with the functioning of the facility, we're going to look as to whether historically you were able to get access. This is not then a body of doctrine which is putting an emphasis on political participation. Jim says that the best example, the absolute best example illustrating the theory is the body of defamation law. Well, let's look at it for a moment. I've already said New York Times puts some limitation on political speech. Jim's response to that is, yeah, but it's a very high standard. Now let's look at public figures rather than public officials. Same standard applies. Who are public figures? Well, Wolfgang Puck is a public figure. He's famous. Lady Gaga is a public figure. She's famous. But the head of Goldman Sachs or the head of a major health insurance company is not a public figure unless that person has deliberately thrust himself or herself to the forefront of a particular public controversy, undefined, in order to determine the outcome. What if a private citizen in a public context engages in defamation? The standard is not a high standard there. The standard is negligence. And what if a private person defames defames someone on not a public issue? I want to make 2 points about this. At the moment, one could read the Greenmoss case to say that the standard, Gertz doesn't apply, that it's not negligence. But the Greenmoss case, a 5-4 decision, involved a credit company talking about a corporation with respect to whether or not it was bankrupt. It didn't involve the kind of individual self-realization and so forth that we have talked about. And prior to Greenmoss, for 25 years or so, such defamation was protected under Gertz in the overwhelming majority of states. And that first article I wrote 32 years ago argued that private defamation should be as protected as public defamation. Okay, finally, I want to mention the Connick case because it illustrates the differences between us. The Connick case, if we indulge the fiction that criticizing the district attorney is not political speech, turned on the fact that it wasn't political speech. Under the political participation view, it was therefore properly decided. Under a view which accents dissent and is concerned about injustice in hierarchies, even in managed domains, we should be encouraging dissent to the extent that it does not I agree that the government has a stronger interest in managed domains, but it should not be able to go scot-free and be free of criticism by employees, by students, and professors, for example, in managed domains should have academic freedom, both in terms of their scholarship and to criticize the institution. I am not saying that political participation is not important. I am saying that sometimes the political participation value does not give us the right results where a dissent value should be. Finally, I don't say dissent should always be protected. I am not saying it is the only First Amendment practice or value. I still maintain an eclectic approach to the First Amendment.
We know why you were picked for this panel, among other reasons. Eugene, it's up to you now to maintain the standard of timeliness that has been set by the rest of the panel. Thank you so much.
My pleasure. Thank you. Let's see if we can get this to work. Oh, you did a moment ago. Let's see. Okay. So I'm not much of a theoretician. That's not the stuff I do. I do doctrine, generally speaking. I try to come up with what I think are sensible rules in particular situations. More to the point, since few people actually want to know what law professors think the bottom line should be, I try to just work at identifying what the arguments could be in particular areas. So that's what I like to do. But in area after area, I've come across these arguments that certain speech should not be protected when it's not a matter of public discourse, and more broadly and increasingly come across arguments that it should be that there should be just a categorical, general First Amendment principle that speech is not protected, or at least not substantially, not strongly protected, perhaps is a better term, when it's not a matter of public discourse. Think of it as either a freewheeling First Amendment exception for speech on matters of private concern, or as Robert suggested, a scope limitation, that before you get to protection, just like you've got to have something that could in some way be called speech, or at least expression, you likewise have to have public discourse. The main problem that I have with that is not that I think that the First Amendment is not about democratic self-government. I think it in large measure is. I think it's also about search for truth and marketplace of ideas, but contrary to Robert's and James's position, I think that those actually go very closely hand in hand. It might actually be about self-expression and autonomy, but in many respects I sympathize more with the more instrumental theories of the First Amendment. The trouble is I have a very hard time pinning anybody down as to what public discourse really means. Now I realize I can't demand a precise, crisp rule that will give us a mechanical answer in every situation. Law, unfortunately, does not work this way, at least in most cases. The trouble is I can't even get an imprecise rule, and maybe I'm just not listening hard enough, but I don't really see it. So here's one possibility. Maybe public discourse is speech by which public opinion is formed. That's an interesting approach, and in principle I would agree with this in considerable measure, among other things because it's very capacious. Public opinion is formed through a lot of things. Public opinion is formed, among other things, through commercial advertising. It is formed through sexually themed speech. It's formed through a wide range of things. So if the question is whether it's speech by which public opinion is formed, okay, if that's the test, that's not much of an exception at all. Maybe there may be some exception in a few situations, but it's not much of an exception at all. I'm fine with that. But then we get to other definitions. What about speech that's essential to democratic self-government? Now here we're starting to make it sound like something that's a lot narrower. Maybe speech might be a way that helps form public opinion, but is not essential to that opinion, or at least to the democratic self-governance portion of that opinion. That could be much, much more demanding if you view essential as strictly necessary. But here's the interesting thing. Public discourse includes all the communicative processes thought necessary for the formation of public opinion. Art and other forms of non-cognitive, non-political forms of speech fit comfortably within the scope of public discourse, presumably because they help form public opinion, but they're also seen as necessary for formation of public opinion. So maybe essential and necessary is not the strong necessary that we see, for example, in strict scrutiny, which is, although there it's a question of whether government regulation is necessary. Maybe it's the weak necessary we see in the necessary and proper clause. Possible. Necessary is a famously fluid word. I'd just like to know which one it is. because I'd like to know what's going to be covered and what's not, because then that is when we can start thinking about what the practical effects of the doctrine will be. Now here's another definition, essential democratic self-government. Well, that could be pretty broad if essential is read broadly enough. But essential to democratic self-governance, but does not unduly impair important governmental or private interest. And that formulation, speech could be extremely political, could touch in political debates, touch directly in political debates, but not just be unprotected because of a countervailing interest. It wouldn't even be treated as public discourse at all. Okay, well, that's interesting. One thing that we're seeing now is we're now moving away from public discourse as a term that is really terribly helpful, because you can have speech that's extremely public and is certainly discourse and is part of discourse, but lost its status because of countervailing government interest. Not usually something we think of when we think of is it a matter of public concern. We say, well, maybe that would be weighed against its public concern value, but wouldn't think it's part of it. This is like the famous First Amendment actual malice test, which is neither malice nor actual. I suppose the law sometimes does that. I just don't think that that's an asset to law. It would be nice if that's really the test. It would be good to have a particular, have a more precise, let's say at least a different term. Here's another possible definition. One measure is whether the First Amendment requires the speakers and audience for the speech to be regarded as autonomous, as opposed to the speech being a mutually constitutive act. Now again, maybe I'm missing something in the way autonomous is used here, but that becomes very hard for me to even understand what the boundaries of the test are. Or perhaps maybe you shouldn't care whether it's hard enough for me to understand it. I just think it would be pretty hard for judges to predictably apply it. Let me give a specific example that I believe, unless I'm misreading the articles, I believe is offered as an example of where this pays off. That public concern libel, I say something about the mayor versus private concern libel. I say something about the mayor's public policies versus private concern libel. I say something about an acquaintance of mine's supposed sexual infidelities. The former is, I think, very strongly protected. The latter is considerably less protected. That's fine. Both actually are quite protected in a very important way that if it's true, at least it's the libel law, modern libel law would be considered fully protected, or if it's opinion, fully protected. But still, let's just work with the fact that some important part of protection is for erroneous false statements. I'm protected from liability for erroneous false statements about the mayor's policies, but not about my neighbor's sexual infidelities. But at least under the definitions of autonomous that I understand, I don't see any difference here. My neighbor and I are autonomous in the sense that we are not. It's not like we run each other's lives. It's not like I am his boss in all matters and I direct what he does. The mayor and I are autonomous. It's true we're mutually constituted in that we're both within a particular social structure, and we care about what the other person says, and we may be injured in some ways reputationally with what the other person says, but that's true in both situations as well. Now maybe what's going on is that the test is not whether speakers and audience are autonomous in any pre-existing sense of the word autonomous, but rather whether the law should label them autonomous. At times I get the sense that that's what's going on, that it's whether it's for the speech to be regarded as autonomous as a matter of legal labeling. Again, maybe I'm just not grasping what's going on here, but if I'm right but if that is indeed not even definition, but the use of the word autonomous, then I'm not sure there's any definition being offered. Because it's not like speech is a matter of public discourse when the parties are autonomous. It's whether they should be regarded as autonomous from the perspective of whether the First Amendment should offer protection. So then speech as a matter of public discourse becomes just shorthand for saying this is speech that ought to be First Amendment protected. But then the question is, what is the speech that ought to be First Amendment protected? Again, maybe the failing is mine, but I don't really see what the definitions really are. Sometimes the talk is about mediums being essential to democratic self-governance. Remember the example of the bar and the new dancing in the bar. And they said, well, bars are not a medium for speech. Well, if there was a bar band playing some music, especially some music with lyrics, let's just make it very easy, and the government decided this is bad music with lyrics to be playing around possibly drunk people who might get the wrong impression for it or act badly as a result, I think we'd pretty clearly say that this is constitutionally protected, even though it's still in the bar. Now, maybe what's going on is it's music as opposed to dance is the test. And maybe that actually does reflect what the court has been thinking about. But there, it's not a matter of essential to democratic self-government. I think rather, to the extent there's a distinction being drawn between music and dance at the medium level, it's that music has historically been just much more of a means of communication. Dance, could communicate at some level more elevated than I personally at least perceive. But in general, I think dance is seen as at a medium level as sufficiently non-cognitive, I shouldn't say non-cognitive, but not expressive of particular ideas or facts in a way that music has generally not been. That maybe there's a distinction drawn. So I'm open in some measure to medium distinctions, but note, the medium distinction that I saw offered was between bars and cable. That can't be the right distinction. So again, I'm not sure what distinction really is being put in play. Well, maybe the examples can help. How about copyright infringing speech, the example that was given of speech that's not a matter of public discourse? Trouble is, as Steve pointed out, Harper and Rowe v. Nation Enterprises, the case that says that copyright law is constitutional, involved speech that was emphatically part of public discourse. This was pre-publication of Gerald Ford's memoirs. Now, it's true, maybe you might say, well, it's not essential to public discourse, because after all, the premise of copyright law is you can express the facts and ideas through other means. So it's not essential. In fact, the court did argue that, look, copyright law doesn't materially burden communication because of all these other mechanisms. But the same thing could be said about vulgarities in Cohen v. California. The same thing could be said about flag burning in Texas v. Johnson. Whatever's going on in the copyright cases, I don't think has to do with the notion of essentiality as such, nor is it, that is to say, with the notion that it's just not that much of a burden on speech, nor does it have to do, it seems to me, with the notion that the subject matter of copyright is not a matter of public discourse. In fact, overwhelmingly, the subject matter of copyright tends to be, at least copyrights that are enforced, things that comment on things that the public generally wants to hear, and tend to be, if not political, at least artistic or entertainment that might have potentially a political or artistic component. How about speech between teacher and student? That's another example. The logic of that is that the government could say, we're going to bar the teaching of certain ideas in colleges. Let's set aside government as managed. Let's set aside public universities. Let's just imagine a law. Congress passes a law saying no university, public or private, shall teach these things. Why? Because it's not public discourse. Speech between teacher and student is not public discourse. Or, you can say it in the classroom, but you can't say it individually to students. It can't be right. It can't even be right when applied to high schools. Again, I don't think that public discourse is being used as a crisp enough term here, or if it is, it has a meaning so very far removed from from the ordinary English words of public discourse that I'd at least like to ask for a different term to be used. Lawyers, how about one example was lawyer speech soliciting clients, that the Oralic case said that lawyer speech soliciting clients may be constitutionally unprotected. It's commercial speech and therefore less protected. And there's a companion case, In Re Primus, which held that speech there by the ACLU soliciting clients for a particular public interest litigation is protected. That's offered as an example of the public discourse-private discourse distinction. But if you read Oralic and Primus, they don't talk about that. They talk about whether the lawyer's trying to make money off of this, and if so, whether we think that there's some degree of commercial overreaching. There are lawyers who make money off of clients, have clients pay them to do public interest litigation. There are lawyers who can do non-public interest litigation, but for free. I think the Oralic Primus distinction does not turn on public discourse versus non-public discourse. It turns on whether the lawyer's trying to make money or not, or at least that's how the court explains it that way. I mentioned earlier, and then I was taken up by Sean, I think quite correctly, to say that family conversations about presidential politics are a closed case as to whether that's a matter of full First Amendment protection, I think just helps illustrate that whatever the test is not the proper test. Likewise with writing a personal letter. Public concern cases, we were pointed to two, Connick v. Myers and Bartnicki. Well, those are the poster children for the public discourse test. It seems to me they show much more about what's wrong with such a test than what's right about it. Connick v. Myers, recall, involved a assistant DA circulating a questionnaire to her colleagues about whether the management was behaving badly, what the colleagues' views was about the management behaving badly. It seems to be a quintessential matter of public concern. If it were published in the newspaper tomorrow, nobody would say, my God, what's the newspaper doing? What business does it have writing about it? Of course it's its business to write about that. What's more, the court specifically said, look, if it weren't a matter of government employment, this speech would be constitutionally protected. I don't think it was generally saying it's a matter outside the scope of the First Amendment. I think the court got it wrong in calling it a matter of not public concern. But in any event, it seems to me that unless Robert and James are looking for a vastly more speech restrictive proposal than I think that they actually want, I don't think Connick should be a case that one should embrace for that. That should be a case that one has to apologize for, at least I shouldn't say apologize for, try to differentiate oneself from, and to say, well, the public concern test in Connick, well, all right, that doesn't really work, but here we're going to try to come up with something else that doesn't have the vagueness and the difficulties involved in Connick. Likewise in Bartnicki, so Bartnicki involved the question whether a third party could be liable for publishing an intercepted communication by somebody unrelated to him. And the court said, well, yes. I'm sorry, no, he couldn't be held liable for it. This is constitutionally protected, but it stressed that it's a matter of public concern. There it was, overheard communication between union members apparently planning a violent attack in the context of a labor dispute. The interesting thing is one of the examples the court gave of things that are a matter of not public concern are trade secrets. Well, trade secrets aren't just the formula for Coca-Cola or the names of a customer list. Trade secrets are a company's plan for a new product. Trade secrets are a company's plan to close a plant or to buy a new company. All those things are trade secrets. Now, maybe there are good reasons, again, to restrict that kind of publication of illegally intercepted or leaked trade secrets, just like there may be good reasons to give the government a lot of flexibility to restrict employee speech in the workplace. But to say, as the court did say, well, that's just not a matter of public concern, just shows how malleable and dangerous the public concern test is in the absence of a crisp definition. Let me just close with the badly named, but I think aptly named, presumptive, I shouldn't say badly named, the presumptive all-inclusive approach. I think that is James' formulation of the approach that I take, and it's my fault. I don't know of a better name for it. It's a pretty clumsy name, but it at least has the merit of accuracy of description. That generally speaking, communication is constitutionally protected unless there's an exception. And the court is willing to carve out exceptions, sometimes does look at the apparent significance of the speech in various contexts, but tries to come up with relatively precise rules rather than reducing things chiefly to the matter of its public discourse. That's what the court has said. It's said it in cases like, for example, Sable Communications v. FCC. Hard to see much a matter of public discourse under any strong definition of public discourse in dial-up porn, but restrictions in dial-up porn were held subject to strict scrutiny. That's what the court said most recently in United States v. Stevens, the dogfighting case. One of the government's rationales was, well, look, this law is constitutional because, after all, it's limited to speech that is of serious, it has an exception for speech that is serious, scientific, literary, artistic, political, journalistic, etc. value. And the court said, well, we've never considered serious value to be a precondition for First Amendment protection. And in fact applied something very much like strict scrutiny to that restriction, even though the examples it gave of the kinds of speech that would be restricted, such as hunting magazines and the like, are not things that seem terribly, terribly close to democratic self-government. So I think that's what the court says. That's also the way the court articulates just the test. We ask whether the speech is within an area of constitutional, of an exception. If it is not within an exception, then we apply strict scrutiny, at least so long as the regulation applies to speech based on what the speech communicates. There are exceptions. There may be the need to come up with new exceptions. It's an interesting question why certain kinds of speech can be regulated under antitrust laws and the like, speech including that may have some considerable public concern-related value. But I think that that's the right approach. And of course, there are also government as proprietor rules, but government as proprietor rules that are imposed in speech, even though the speech is, both by terms of content and by terms of its practical social function, is a matter of public discourse. It's just the government as proprietor, whether it be employer or funder or a K-12 educator or whatever else, has considerable latitude for a variety of reasons, which Robert, of course, has well explored in his other work. Finally, I just think it's a sensible allocation of burden. I mean, people say I'm a First Amendment absolutist. Nobody's a First Amendment absolutist. Even Justice Black said he was, but he wasn't. I'm certainly not. I'm open to carving out exceptions in certain contexts. But it seems to me quite reasonable to say that the burden ought to be on the government to explain both why speech should be restricted and to articulate a relatively crisp and sharply defined rule that tells us what speech would be restricted. And then for the court to accept or reject or modify that rule and give us a specific explanation for it. And that's the kind of, at least, precision of definition that I'm looking for, that I would like to see before either a narrow restriction or especially sort of a freewheeling recipe for restrictions is accepted. And with that, I close.
Excellent. Eugene, you packed 4 hours worth into 20 minutes. Very well done. I'm going to ask the two presenters, Professor Post and Professor Weinstein, to come up and respond, if they will. Well, taking as much time as you must.
With all deliberate speed.
Yeah, that's good.
Not yet.
Thank you. You should take as much time as you feel that you need to, except that I do think what we want to try to do is close this by 4:15 at the latest, because we do have another panel. We might want to take a few minutes break in between. So just to let you know, and after you are done, we'll see if there's time for questions from the audience. Would you like to go first?
I think I've just been nominated to go first. So, yeah, thank you. So this is a lot to respond to, obviously. Let me start working backwards with Eugene and review what are the stakes between the presumptive all-inclusive approach, which he puts on the table, and an approach which says, actually, there are limits to decide, and we need some coherent, justifiable limits on when it is that we have speech for purposes of the First Amendment. So when Eugene was talking about how we should start off, he said speech should be presumptively, he said communication, I think that was the word you used, communication should be presumptively protected unless we have a good reason to regulate it. And it's exactly that assumption that I want to query, that we started out this morning by querying, namely, what's communication in that sentence? If communication is communicating something, we're back to 9/11. We're back to, well, the example that I use all the time is aeronautical charts, right? You have somebody draws charts for an airplane. They put the mountain in the wrong place. The airplane runs into the mountain. And then they sue the chart maker for negligence or for whatever. And the question is there a First Amendment defense for the chart maker? Remember, on the table here is the issue of whether there's a First Amendment defense, not whether the speech is protected. Neither Jim nor I have talked about the question of when speech is immunized, what are the substantive standards for protecting or not. The question, the most precise question is, should there be specific First Amendment doctrines applied in the case? And there are many different kinds of First Amendment doctrines that provide different levels of protection, and we're leaving that at the moment bracketed. The question is, should there be any First Amendment doctrines applied in defense of the case? So the chart maker gets up and says, it's communication. And I meant to communicate that, and that communication was successful. That's why they stared into the mountain. And therefore, there should be a special First Amendment doctrine of some kind applied to me to give me some form of immunity in this case. No court has held that. No court has held that, nor would they. Now, it's not that there's some special interest in charts or special interest in navigation or special interest in pictures, however you want to formulate the interest. It's rather that people, even though it fits every common sense definition of communication, it's just not regarded that way for purposes of the First Amendment. And actually, I think that case is more typical of communication than the presumptive all-inclusive approach. And the reason for that is actually very simple, but we just never think about it. It's a question of what's the foreground and what's the background of this thing. If you think about what communication is, almost everything we do is mediated by communication. And that means almost every form of legal regulation can be understood as a regulation of the communication that makes possible institutions and relationships, et cetera, et cetera. And so the question of whether we should have a particular First Amendment doctrine in any case is the question of whether this form of institutional regulation by law, regulation, say, of aeronautical charts, should have special constitutional dimension. So how do we answer that question? And I'm just, the initial suggestion was we ought to answer that question if this form of regulation raises the kinds of values that we want to use the First Amendment to protect. Otherwise, we've constitutionalized everything. We've made the First Amendment virtually unavoidable as an issue in most forms of legal regulation. So what are those purposes? And then we're back into the question that we started this morning with. So that's the stakes in the kind of approach that Eugene puts on the table. And I just want to say, I don't think it's so circular to raise the question in terms of whether we want to, the law wants to, when I say we, I mean the law, wants to ascribe autonomy or not to a particular set of relationships. So the example that when I teach this I use is a case called Winter, and it's about a book called The Encyclopedia of Mushrooms. And Winter, and in this book, what it does is it gives you the mushrooms and the pictures and what's safe to eat and what's not safe to eat and so on. So you can imagine the case, real case. They get a mistake, somebody goes out and they pick a mushroom that the book says is okay, they eat it, they die, the estate sues the publisher. Query, First Amendment defense or not First Amendment defense? Well, how do you decide that issue? Whether the First Amendment, leaving aside whether the speech is immunized and there's protection, or it should be negligence, or it should be whatever, there should be a constitutional question in that suit. How do you decide that? Compare it, on the one hand, to instruction manuals for cars. Toyota gives you an instruction manual for how to repair your brakes. They get it wrong. You have an accident. You sue. I guarantee you there's not going to be a First Amendment defense by Toyota. They're not going to be able to say, gee, that manual was an experiment as all life is an experiment. They're just not going to be able to say that. There will be no constitutional defense. So is the Encyclopedia of Mushrooms like the manual? Or is it like the example I began the day with? The doctor writes the book saying, cancer is really a matter of eating apricot pits, and if you eat apricot pits, you don't need to go see your doctor because you'll be fine. And he publishes a book like that. And if that doctor gets sued, for sure there's a First Amendment defense. And which is it like? Well, I don't think there's an answer to that question. I think that's a matter of whether the law wants to treat the relationship between readers of this book and this book like an instruction manual, which is a perfectly intelligible thing to do, or whether like an aeronautic chart, where the pilots and the passengers are dependent upon the chart being accurate. We, the consumer, are dependent upon Toyota getting it correct, or it wants to treat our relationship as autonomous, namely, it's caveat emptor, which is what the First Amendment tends to do. It tends to say you're autonomous, you can't be held to be dependent strictly on what the person has said. There are certain kinds of thresholds you have to jump to. That's the legal question about whether there is First Amendment coverage, to use Fred's word. And the court has to decide that. And as they decide that, they construct the social relationships, but they also have to decide what should be. It's perfectly normative in the sense that was being described here. What should be the relationship here? And public discourse is a way of saying, you know what? When you decide whether or not the First Amendment is involved, you are constructing these relationships. You have to be answerable for constructing these relationships, and you have to understand what sort of relationships you're constructing. And you have to have, and this is going to Steve and Fred now, you have to have some account of why you're constructing the relationships in this way. It could be the case that there are simply contextual judgments. I don't know, you know it when you see it, and it should be, these guys should be autonomous. I don't know why, but they should. Or it could be that there are many values, and it fits this value. And but the big picture with regard to the comments that we saw from Steve and Fred is the transparency of the law. I mean, one of the values traditionally ascribed to the rule of law is that the law have an internal coherence, that it be in some way predictable because it's coming out of some common understanding of what its functions and purposes are. We can predict where it'll go because it has an internal coherence, something like that. Of course, the law never fulfills that expectations, but it's a regulative ideal we tend to project onto the law. And I think in this, the debate you're seeing here about is the First Amendment one value or four values or two values or an infinite number of values is exactly how coherent is it? And according to what lines is it coherent? I think that's the internal tension here. And I suspect if one were an historian and one were looking back, one would say, yeah, there's lots of things at stake in the First Amendment. If one is looking at judges and trying to give them help in making the law coherent, to answer to the regulative ideal, you would want to say something like, you have to understand yourself as unfolding a certain set of purposes. Here's the clearest set of purposes, excuse me, I can put on the table for you, and that's why. And I think this debate is about that question. And I don't think anyone on the table would say it's one thing, it's only one thing, and everything has to meet that standard. I wouldn't subscribe to that, but I would say the best account I can give and the clearest account I can give to understand why people are autonomous in winter or not autonomous in winter has nothing to do with the autonomy of readers of the Encyclopedia of Mushrooms. It has to do with what sort of social institution the court is creating with regard to books like the Encyclopedia of Mushrooms. And it seems to me the most helpful way to understand that question is with respect to institutional considerations. And that's why in my own work, I don't want to speak for Jim, but in my own work, that's why I've tended to take it toward social accounts. And to me, actually, the best predictor of First Amendment outcomes would be the work of a sociologist like Irving Goffman. It's precisely because speech is a terrain that covers everything we do. You'd have to have a very discrete set of the social understandings in any Speech Act situation to understand actually what the intuitions of a court will be. And they're very much allied to the institutions they're explicating. And the best help you can give to somebody doing that is to give them a puzzle in which the institutional pieces fit together at an institutional level. That's why I gravitate toward the kind of explanations that I do. What else do I want to say? I guess that's plenty.
Eugene asked for clarity and or certainly raised an objection, and most of the terms up there I think were Robert, some were mine. And I don't want to be candid, and I want to say that you can't really derive from those terms an algorithm or a precise roadmap for deciding each case. What's going on, as Robert has said, is all this has to be normatively determined, but not, and this is important, not on a case-by-case basis, not on an ad hoc basis. We've all talked about how what you want is to generate rules, particularly in the First Amendment area, wherever possible. I think Steve talked about rules and centers, but I think he was leaning towards as much rules as possible. So what you're going to do is you're going to use those terms that you find correctly somewhat indeterminate, and those standards at that level to generate rules, those descriptions, and it will have to be, as Robert says, normative, and it's going to fill out, the story is going to fill out from time to time. And just to say something that Susan said about with autonomy on both sides of the ledger, is she said it's the same. Just I wanted to sort of say that now and just disagree. That's always going to be ad hoc. This is going to be definitional and rule-based, which I think is an enormous advantage. Pragmatically, Eugene and I share a very strong concern about doctrine working in a practically administratable way that tries to keep as much of the sort of the judicial viewpoint discrimination, the law enforcement judicial viewpoint discrimination out of the mix. And I wanted to say one thing more about the all-inclusive approach and why with all its problems that you pointed out, why, because everything is relative. You have to choose, it's like democracy. Public discourse is like democracy. It's bad except for all the worst, it's worse except for all the others. And it's certainly better than the all-inclusive approach for the, in addition to the reasons that Robert has said, what I think is very problematic about the all-inclusive approach is it's going to weaken this core right of dissent that Steve White said is really central to the American practice. Because, first of all, you're going to generate, as Eugene suggested, all these exceptions, and you ask why these exceptions. What's the theme for, and talk about uncertainty, what ties all these exceptions together? Not some theory, but what's really going to be problematic is there are going to be cases, like the map example, like the teacher using Mr. Cohen's favorite word, Johnny, can you say fuck to the secretary? We're going to stop that speech. And if you're going to apply strict scrutiny across the board, strict scrutiny is going to get very weak. I think you're seeing this a little bit already with the courts and the Holder case with the terrorist organization case. What is that versus Holder?
Holder, humanitarian law project.
Humanitarian law practice. You see strict scrutiny getting sort of weak in there. But boy, I think it would be a disaster if you adopted an all-inclusive approach and say, well, there's a strict scrutiny for the carpet cleaning instruction that was wrong at Yale, made your carpet yellow, and that passes strict scrutiny, and so then, well, why not anti-war protests that dispirit our troops and encourage the enemy? Well, that's certainly going to pass strict scrutiny. So I think it would be very, very bad for pragmatic reasons, Eugene, to have an all-inclusive approach, because the pressure to find speech regulable under some strict scrutiny setting will be irresistible, and there will be lack of protection will be needed most at the sort of core of dissent. I wanted to say with Vince, so I really like that sort of an overview of these various theories. I have to say that what I really appreciate is that you really have, and maybe I'll speak for Robert here, I think it's safe. I think you really get it, there's the individual-centered theory of democracy, and so I just have very little disagreement with what you say, although it reminded me of, what philosopher did they say this about, that he would state his opponents better than his opponent could state, and then destroy him. I mean, later in your written article you do that, but I just want to compliment you for so very well understanding what I'm about, and I'll let Robert speak for himself, but I think he agrees with me on that. I know he does. And just one part of disagreement, when you said, when you were talking about additional theories about sort of this distrust of government and why speech might be an abuse of regulatory power and free speech. I think it's a Fred Schauer, in his terrific book, A Philosophical Inquiry, makes that thing, when I would be so bold to say it's a mistake. You can't be making pragmatic arguments like that without some underlying theory. So it's not that we distrust government regulating speech all told. It's we mistrust it in certain situations, and that's going to bring you back to some theory, and I suggest that it's the political one, the dissent one. Now, while I'm on dissent, and just to go to what Steve said about dissent, well, sure, that is very much in our tradition, the speech that we hate needs the protection, but surely can't operationalize that in the sense, because surely I take it, Steve, you don't want to say, if you're dissenting from the status quo, you're going to get protected, but those people who want to get, conservatives, if you would, I don't know, I hope not, conservatives, if they want to get out and speak for the status quo, they don't get protection. So I think we just have to round it off to be a right to very vigorously, with lots of protection, to be able to vigorously and vituperatively question or support all the norms that constitute society. And I don't think we can cheat one way or another towards dissent, although hopefully what will come out of that is that dissent is adequately protected. You make a good point about the public figure case, Steve, being wrongly decided, extending the malice standard from public official to public figure. The court was wrong to do that, but that doesn't disprove, that's not inconsistent. It doesn't contradict a public discourse theory, or it's extending speech to, it's overprotecting speech, like Citizens United on, as I said, charitably construed, overprotect speech for the Micheljonian view. I don't know why they were, how we can reconstruct what they did with public figure. I would agree with you that it's wrong. But I don't think that embarrasses the notion of a theory committed to participatory democracy. I do think you make a good point and a stronger ground, and I think that Vincent, his written response, makes this point too, that the public forum doctrine, certainly Rehnquist court, does not show, by my lights, enough a concern for participatory democracy. But that's gonna be a judgment call. That's one of those normatively defining matters. And it's also probably, as I think I said in my written response, it's not as bad as like the airport cases. If you say, well, it's not a public forum, but you look what they did. They gave more protection than the language of the majority opinion said. So, but that's a good point. And I guess I'll just finish by coming back to Fred and saying, surely there are all these, if you want to put it the way you did, is different First Amendments, all these values that are in that mix. If anyone, if you're not going to use it like a drunk in a lamppost or looking at it, your friends, you're going to have to see that there's all these values. But the only thing I'm really suggesting is that we say that we need a core, because otherwise, as I said this morning, if you've got too many values without lexical priority, you can do anything you want, which will be as much of a disaster. Well, it will lead to the all-inclusive approach. So you need some a lexical hierarchy. Or the way I think it is a core with peripheral and then or important values around the core, like the instrumental to the democracy, and then marketplace of ideas as being perhaps peripheral. But it's all in there, but it does have to have some ordering. And I think that a fair way to do it would be with participatory democracy, because it does, despite some of the overprotection and the problem with why does some private speech get so much protection. I think it really does explain the pattern much better. Again, it doesn't explain it perfectly, no, but it explains it a lot better than any alternative theory. So already it has that fit, which I explained this morning why that's important, and it's a very attractive norm. It's one that is uncontentious, And it's essential to our modern understanding of democracy that we all have the right, the individual right, to get out there and try and persuade people. Maybe I disagree somewhat with my friend Robert, that we're trying to see ourselves and somehow or feel warranted, a warranted conviction that our government is taking us seriously. That I'm not so sure of. It's just more that the government's going to use coercion on me to make it obey its law, at least, at minimum. Necessary but not sufficient. I've got to have a right to be able to give my view on it before it's going to throw me in jail for violating the law for us to pass. No, leave it at that.
One of the I'm glad I took notes, but one of the disadvantages I have to read them. So, read my handwriting. So I just wanted to add 3 quick points. The first is I almost always find myself in agreement with Vince, and to the extent that we want a First Amendment that's able to protect us in hard times, pathological times we need an account of what's core and what's not. And that would be in some tension with the account we heard from Steve and Fred. I just want to make that point. So a second point regards, Steve, about, you said at one point, what you want is, we can disagree about our rationales, but what's really important is to have clear rules that are laid down across the board. And I want to say, if there's one thing that drives me into writing about the First Amendment, it's frustration at what the court regards as a clear rule applied across the board, which, so far as I'm concerned, is garbage in, garbage out, like no viewpoint discrimination. I have no idea what that rule means. It's applied in 50 different ways, in 50 different contexts, and it may give certain members of the court satisfaction that they are applying a rule, but when you actually look at what they're doing, it's incomprehensible to me. And if there's one thing motivating the project I want to put on the table, it's to say, what you mean by viewpoint discrimination has to be determined by a context, by a purpose, and you're not asking that question. So I think that precisely because the court has tended toward Eugene's theory of speech as such, and they want exactly what you're thinking is desirable, these rules across the board, they are led to a whole set of doctrines which are, to my way of thinking, both misleading and incomprehensible, if that's possible to conjoin those two things. And the third point about what I wanted to raise about Fred was that if you're captured by a tradition, you're inherently conservative, and you're not asking the zero-based budgeting question of should we have a First Amendment at all. And of course, it's true, you're not asking that question. I suppose the issue is suppose you were to ask that question, who would be your audience when you write about it? And one issue is one of audience, namely, who are you writing for? Who is zero-based budgeting in the area of constitutional law, really, when we think about it? And I myself would eschew that project for myself. I'm writing to people who are already thrown into the middle of a system and are trying to do the best they can within the system they have. But the issues that you put on the table, which is comparative freedom of speech in different constitutional democracies like New Zealand and France and the US, it seems to me exactly right. And of course, this goes to a question that Shauna asked me over lunch, which is, why are you addressing yourself just to judge-made law? Surely these are constitutional values addressed to the population. And I think that's right. That's an excellent point. It is true. This is the First Amendment values that Judge Kaczynski said was dead, namely the late, great First Amendment. And then he's talking about the fact that we're not nourished by public discourse in the way we should be. That's not a matter of judicial regulation. He's talking about the value of the First Amendment, which is a more general political value, of course, which we should all think about and be committed to, and ask ourselves how whatever values we have as a culture. And many societies implement these values in ways other than judicial review. New Zealand would be an example of that. And many have forms of the constitutional value that are different than ours. Fred's list of how we are exceptional is correct. And then the issue, I think, for more fundamental theory is to understand why they can also be democratic. What are the different trade-offs? And what are the prices of those trade-offs? And why is it we make certain trade-offs and not others? And to clarify that, I think, is a terrific project.